All right, this is case number 21-50724. This is Midland Credit Management versus Ursula Richardson. The matter is set before the court for a final pretrial conference, it seems, and settlement conference, etc. All right, your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Brian Truba, appearing on behalf of plaintiff Midland Credit Management. My P number is 61752.
All right, thank you, counsel. And in your pathway trying to get here, I know this morning you went to Judge Brew's courtroom, who was the predecessor on this docket. Did you come across Ms. Richardson at all?
I did not, Your Honor. And just so the court's clear, I think on your waiting pages, it tells you to go to different courtrooms still. So you guys might have to fix those. But to answer the court's question, I did not.
All right, very well. So what's the status of things here? I know that there's been quite a bit of activity. It looks like there was also a motion for summary disposition that was filed back in, looked like in February. Go ahead, sir.
That's correct. That's correct, Your Honor. She did respond to the motion, but that's all the communication we've had since that motion was filed.
All right, thank you.
So, yeah, Judge, we served discovery on her. She didn't answer the discovery, but she did respond to the motion. And that's according to case for final pretrial.
All right. I do see the response to the motion. Defendant's response and affirmative defenses to defendant's motion for summary disposition. Just one moment, counsel. All right. So give me the general nature of your SD motion, if you will, sir.
Your Honor, my client's the assignee of the defendant's Meyer credit card issued by Coleman Bank. This particular credit card was opened in March of 2005 and charged off with a balance owing of $4,311. The statements went to the defendant. They were addressed to her. They went to the address she's using in these proceedings. I reviewed the statements this morning. There's purchases, there's payments. So she filed a response, Judge, that said something like, I disputed it on my credit report, and plaintiff is coming to court with unclean hands. Judge, back in 2000, she did dispute it with my client. My client investigated it, didn't find any merit on it, and instructed our office to proceed. Early this year, Judge, in January, we served requests for admissions on the defendant. She didn't respond to those. Based on those admissions, Your Honor, she admitted the balance, getting the statements, having the account. The exhibits we attached to the motion support the balance on the account. And then Coleman Bank actually sent the defendant a letter on December 18, 2018, indicating that the balance of $4,311.99, which is the pseudo balance, was owed on the account, and that the account was being sold to Midland Credit Management, and she needed to discuss the collection of the account with my client. Your Honor, the motion supports the fact that the defendant had the account, she made payments on the account, and that my client actually owns the account. So we think we met all the elements. Looking at the defendant's response, I don't see any, she doesn't attach anything. She doesn't raise any material facts that would inhibit this court from entering judgment at this time.
All right. And I have read the response in this matter, and it does seem to raise issues with respect to the efforts by the defendant in this matter, Ms. Richardson, to resolve the issue by way of denying the issue and indicating that that she should not be charged. There's nothing that gives any specifications as to why she believed that the plaintiff should not, or that this is not her debt. She simply indicates that in paragraph number 3 that plaintiff obtained an order regarding alternate service as a means of using false, misleading, and deceptive means representing its complaint to the honorable court, and seemed to raise that as one of her bases for saying unclean hands. Then she also cites the Fair Debt Collection Practice Act, and indicates that plaintiff should be disqualified from obtaining relief for using false, misleading, deceptive means for the purpose of unfair debt collection. So her attack seems to be upon the debt collection and not upon the debt itself, at least on the court's reading of this matter. I am sensitive to the fact that with the recent and sudden transition from Judge Brew to this court, that people are perhaps getting lost in the shuffle. On that basis, I will take the motion for entry of the motion for summary disposition. I'll take that motion under advisement. My inclination is that the motion likely should be granted. I want to give the defendant an opportunity to come in for a hearing in that regard. If she does not appear for the subsequent hearing, then the court will enter the judgment, will grant the motion for summary disposition and enter judgment thereupon. So I'm taking that under advisement, counsel, and I'm going to issue the order.
Your Honor, given the shuffling of the courts, I would completely agree with that. Even like I indicated earlier, even I got confused trying to find which courtroom I'm supposed to be in this morning.
All right, so we're going to get that. I'm going to go ahead and get that order out today. We're going to set this over for. I'll go ahead and give it the 8th of June, June 8th, and that's going to be at 9:30 a.m. June 8th, 9:30 a.m.
Okay.
Motion for some disposition is taken under advisement and set on for hearing and/or entry on that date. And the order will indicate that the court specifically set a new date in light of the fact that the defendant was not present at this hearing, and she must be present at the next hearing. It will have the Zoom number on it as well.
Okay, thanks, Judge.
All right, so you got that date. That's the 8th of June at 9:30. June 8th, 9:30.
I do, Your Honor. All right, thanks, Your Honor. Have a good morning.
Good day to you, sir. All right, and I'm looking at, I'm gonna call you Dominique because I'm having a problem working out the last name. So go ahead and help me out. Good morning to you.
Good morning, Your Honor. Dominic Silvestri, P65275. I'm here on Michigan Insurance Company versus Faith Shelley. Unfortunately, I was in front of Judge Brew all morning, and when my case was called, I was informed that I should be in front of you instead. So I apologize for the delay.
Oh, no, not a problem. This is, as you probably heard in that other case, this is what we're running into, and we kind of anticipate this. So I'm going to formally call this matter as case number 2016-5423. This is Michigan Insurance versus Faith Shelley. The matter is set on for final pretrial conference, motion hearing, settlement conference, etc. The time set is 9:30 a.m. This is case comes from the court takes on this case as the successor to the Honorable Demetria Brew. And this is the first hearing, an opportunity for this court to address this matter. All right, counsel, you've entered your appearance. Do I have anyone representing Ms. Shelley or Ms. Shelley on this Zoom at this time?
Not that I know of, and there was nobody in Judge Brew's courtroom either, Your Honor, for the last hour.
Yes, sir. You anticipated my next question as well in this regard. So what's the status of things here? I do see, it looks like there was an answer in this matter. You've gotten through discovery. What's the status? Give me some information.
Your Honor, I'm not entirely sure, to be perfectly honest. I was told by the clerk that there was an answer filed. I requested a copy because I've never received a copy of the answer. But to date, we still haven't gotten a copy. So if there is an answer, I haven't seen it. We did send out some discovery to the defendant at the address where she was served. We've received no response. So I'm not quite sure where we're at here.
Gotcha. I do see that you sent some requests to admit. Is that correct, Counsel?
That's correct.
And I'm looking through the file here just to see if I, in fact, see an answer to the.
You know, Your Honor, one of my paralegals had actually contacted the court and then was told that even though the docket had noted that there was an answer, there was no answer in the physical file. And that may be the reason why you may see a second submission of our default judgment request.
I don't see, I do not see an answer. I know that this was previously before the 17th Judicial District and that a change of venue occurred. So I was looking to see whether or not there was anything generated in the nature of an answer at that court. But on that court's transmittal, there is nothing that suggests that there has been an answer in this case.
Yeah, I'm not sure who noted it or why it got noted as an answer was filed, but it doesn't appear that.
I'm looking through everything here because given that given two factors, one is that there is no answer, but moreover, there is no response to the request to admit, and it looks like those items, the information here suggests, I'm looking for the proof of service. The information suggests that this was submitted to the court March 23rd, so we'd be way past the time to answer. And Counsel, you have indicated that you received no answer to the request to admit.
Correct.
All right. I will grant at this time your motion for entry of judgment by default on the term as prayed in the complaint. The court finding that the defendant has not responded to the complaint and that the defendant has not responded to the opportunity to address discovery and the nature of requests to admit that were offered in this matter as well. So you may submit your judgment by default, Counsel, and I will sign the same.
Thank you, Your Honor. Is there an email perhaps that I can submit that to to your clerk?
Yes, sir. That will be for now and in the future, as long as I'm here, Latifah, LATIFAH .Hunter @36districtcourt.org.
Thank you, Your Honor. Have a great day.
Thank you. Good day to you, sir.
Thank you.
Counsel, Mr. Hill, good morning to you, sir.
Morning, Your Honor.
All right, and which case are you on, sir?
I'm coverage attorney on behalf of Midland Funding versus Evil Walk. I've been sitting in the wrong courtroom this morning.
Yeah, you were part of that. You were part of that group.
Yeah.
And hopefully this all gets ironed out. It was a sudden transition when I was moved from that docket to this docket. So people are kind of still trying to find their way. All right, so this is case number 21-65396. This is Midland Funding LLC versus Evale Walk, W-A-L-K, at 10,000 Trammell Street. The matter is before the court on the course of filing of a general civil complaint. Today is the date and time set for a final pretrial conference. I believe that is where we are at this point. All right, and your appearance for the record, Counsel.
Yes, sir. For the record, William Hill, P28608. I'm coverage attorney here today for Midland Funding. Your Honor, I had it up for a motion for summary disposition scheduled for hearing today. Is that what the court file reflects?
I'm taking a look now, and that would make sense because the way that it was set up by the previous judges that this would be the final pretrial conference date and any motions would be due, would have to be set up for hearing on this date. So yeah, I do see the motion and brief in support thereof. Have you received any response to your motion?
No, sir, we have not. We haven't received anything, any communication at all. I checked with Midland last night, okay, and there isn't anything that we have in our file. No payments, no acknowledgement, nothing. So there wasn't anyone there in Judge Brew's courtroom either checking in on the case when I was sitting in there as well. So I don't know if they've appeared anywhere else. They haven't submitted anything in response to that.
Just one moment. Just looking back through the file for just a moment here. I'm not seeing an answer to the complaint. Did you know an answer at all, counsel?
You know, it said, according, I don't have an answer here, okay? The only information I have is that a judgment was sent to the court for a proposed judgment, okay? And the motion, I'm not seeing any answer. I don't have a physical answer in my file.
All right, I see that. I do see the register of action saying the defendant's answer to plaintiff's complaint. Let me just check one thing. I want to see if that is actually there, because I haven't seen it.
Change of venue.
Says court is in receipt of it. Let's see what we have here. Just a quick file review and I'll make a decision here.
I printed out the ROA on the thing. It looks like on January 6th, it said, court is in receipt of defendant's answer. I don't have that answer.
Yeah, that's what I was looking at.
Yes, sir.
Just one moment. Yeah, I do not see an answer in this file. All right. So I don't see an answer. I'm troubled by the fact that there is a notation in that regard, and so I'll have to respect that notation at this point. On your motion for summary disposition, give me the general nature of your motion, sir.
This is a credit card action, okay? No payments have ever been made, okay? Essentially, let me see here. This was a Walmart credit card from Synchrony Bank. Okay, we've never received any payments on this thing. And that's just, you know, there isn't any defense to it that we can say, as I indicated to you, we don't have an answer to the complaint. Okay, I
It
don't.
looks like in your motion for summary disposition, point number 6, it says the defendant's answer sets forth denials but fails to set forth substance of the matter upon which the defendant relies in support of said denials and otherwise fails to conform to the requirements of MCR 2111. So it looks like there may be an answer. I don't have it in file, but there's an answer floating around somewhere. And so it sounds like your motion for summary disposition sounds in the point that the answer is just a general denial and that there is nothing that has been offered to substantiate any answers, and that the evidence of the indebtedness is overwhelming. Is that basically what you're saying to me, counsel?
Yes, sir.
All right. Given that the defendant has not appeared regarding this matter, of course, the court is sensitive to whether or not persons may be trying to get in this window that is open. But my inclination is to grant the motion for summary disposition, and I will and grant judgment thereupon. I will delay entry of the order until the 8th of June. So I'm going to set another hearing date, and it will be a hearing on entry of motion for a hearing on entry of judgment on motion for summary disposition. And so if the defendant doesn't show up, then the order will be entered. If the defendant shows up, she will have to show, or she or he will have to show good cause as to why the order should not enter. Because at this point, the evidence is overwhelming that there is nothing to contest the complaint that's been filed in this matter. And so that will give the defendant an additional opportunity to come in for the hearing, given the fact that that we've had some Zoom type issues. So that date's going to be the 8th at 9:30 a.m., June 8th at 9:30 a.m.
9:30, June 8th, Your Honor.
Yes, sir.
Thank you very much. Appreciate that.
All right, we'll see you at that time, sir.
Okay, thank you.
Chair, it's gonna take 1 minute, okay? Okay.
The guy who just, the attorney just left, what case was that? What lady was that for? What's the case, the person that just left, what was he here for?
Final pretrial. I'm gonna give you a couple of orders.
Oh, you was, okay, I don't know that. Oh, that's okay. This comes from Kathy. All right. What type of case you have? Okay, that would be just mechanical. So you have to talk to his clerk. So you have their mini ID number. This used to be his courtroom. It's not anymore. You can call his clerk. It'll say call 538, but you have to, this is the wrong number. It's 313-965-3953. Judge Combs' phone. The phone number to the courtroom, 313-965-3953. Correct.
Let's get busy. Deborah, you good there?
Me?
Yeah, I said, are you good there? Everything's good?
Oh, yeah. Everything's
Get
good.
yourself together. Once you got yourself together, we can get somewhere.
I stay together. I'm just waiting on our little case. I don't know. I'll be sitting down in Bruce's courtroom.
Mental, psychological, emotional pain.
All right.
What? Oh, I know my. Uh-huh. Yeah. We all good, y'all, like today.
In the front door today.
On the front door.
Yeah.
Judge Sherman, she's a judge now. So
Oh, yeah.
my old magistrate, she got her parole docket, so she got a felony today. Accident everywhere, so they put me in the front door out.
Oh, oh, oh.
She got a bird in there, so.
Nah, that's not her teeth problem.
Deborah, you okay there?
Yeah, that's what I said. I don't know, Judge. She up there tickling herself. Deborah.
Oh, I'm here. No, I was on Instagram. Somebody posted something real stupid.
Boy, I tell you. People just got them easy jobs.
That's why I tried. See, this is why I try and keep my mic off. So it's harassment that I get from. I'm getting ready to send it to you if I can. Then you'll see. Oh, oh my God, I can't stand it.
I'll be back a little later, Chief. All right, John.
Mhm.
I got you laughing at you.
Yeah, that right.
Now you see, I wasn't expecting that.
Yeah, that's crazy.
Then she tased her.
Mm,
Wow.
mm, mm, mm.
Oh. Mm. Judge, did you, say anything to Burns? 'Cause I forgot that was his last day.
Yeah, I talked to him.
Oh, okay.
The guy, I guess I have to call the guy that works the judge's door in the afternoon. So I'm thinking.
The guy that was what, Judge?
Oh, you talking about the, I know you're talking about, two of the tall men?
No, he's, Tillman works in the morning, but in the afternoon, there's a young man, I thought they were already, I told Brian to let them know, but I guess I gotta let them know.
Yeah, what was his name?
God, Brian told me.
Brownski, you said, I'm trying to think
That's
who
all I
it
know
is.
is Tillman.
Yeah, I only see the tall men. The tall older men.
I talked to the guy, I talked to the officer on Friday too.
Oh, you did? Oh, you didn't know. Judge, you didn't know who he is.
I mean, I talked to him every day when we leave here.
Oh, you do? Okay, that's probably why. Okay. Yeah. I wonder I probably know who he is. He always worked that door?
He always worked that door.
Oh,
After
okay.
Tillman leaves, he works that door.
Okay, yeah. I think
So he's here now. He just, when Tillman leaves, they send him to the judge's door. So
Yeah, cause she, well then you'll feel better, Deborah, cause she thinks she the officer.
No, she can't. She can't.
What you say?
And, you know, I like,
I knew it. I kept trying to drop subtle hits to Tifa.
Oh, okay.
I don't think she was picking up on it. I was like, you know, you can really ask the judge if you could get somebody, you know.
Yeah, cause she was like
you know, she didn't catch it.
This
So
her first time working in the courtroom, I think. This is her first time working.
you need somebody who's worked in the courtroom before, somebody that worked well with you and the judge, somebody that can help you with the Zoom.
Because I think you razzled her a little bit. You got her a little razzled a little bit. You made her a little upset, Deborah.
All I did was ask if she was vaccinated.
Yeah.
she was what?
If she took her, if she got her shot, her vaccination. She talking about she don't like to put what impure things in her body.
Yeah, she said she don't like put stuff like that because she never had no shots or anything. I guess no other shots. She against it though. I mean, she's against it for herself. In other words, not for nobody else.
Let me ask this: Is she no shade? Because I got a problem with weight too. But is she overweight?
She a thick girl. She's short.
I can't see her. You know.
Oh, okay, yeah. She's short. Yeah, she is. She's thick. She's pretty thick. Yeah.
So she couldn't have too much of a problem putting bad things into her body.
Oh my goodness, Deborah. Oh my.
I'm just saying. See, she must be, but she must be young though too, right? She young.
I think she is younger. I think she probably she's younger.
Yeah, she can all like me.
I don't have a problem with none of those things. You do have.
No, but I'm just saying. She's talking about she don't want to put impure things in her body.
Yeah. And I mean, if she don't want to take the shot, I mean, I won't hold that against her. I don't have nothing to do with that. I mean,
yeah, because Deborah was like, we all gonna be in the courtroom, but then she caught herself. Deborah was about to be like, yeah, we don't want nobody in here. Don't got you and shit like that. I got no shot. I guess because we all vaccinated.
I wasn't thinking about that. She got a little bit of know-it-all.
Mm-hmm.
Uh-huh.
Oh, you seen that, didn't you? Oh, yeah, you seen that. Oh, yeah, I did.
Okay, I could tell. Because I picked right up on it when she was saying that. I was like, oh, God, let me just be quiet.
Oh, yeah. Yeah, so she said, well, I'm the officer, the new officer. I'm like, oh, okay. I'm like, well, they didn't even ask. They asked the judge. I was like, how she was going to be the officer?
That ain't going to happen.
Yeah. I
don't have no problem with you. Know how I am, Deborah. I ain't got no problem with her. But she's not.
And see, even you see, because they know you need one. So even he came in white.
Oh, okay.
The guy, because he's good too.
Yeah, you know him, right?
Yeah, he was working with SRT, but since they've been moving around, he been like, I guess she's trying to move or whatever. So that's probably what. He's real cool. He's real good too. She likes him.
No, I'm judge. I can't place him. I can see him.
I need to talk to the supervisor. I want the guy at the door.
Yeah, I
don't know why I get against dog.
Judge, you know you're on YouTube.
I shut the other thing down, and Deborah, that's why when you start talking
Would that right?
He want me to what? If it wasn't for me, Lord, where would y'all be? Where would you be? If it wasn't for me.